that on the record. Our first case is Ebanks versus Ebanks.
May it please the court. My name is Virginia Vetter, and I'm here on behalf of the appellant Diana Ebanks. Present with me also is co-counsel Donald D. Court, who was the trial counsel in this case. And yes, I would like to reserve 5 minutes.
Sure.
Okay. I think a brief review of the chronology is first in order. The parties own 3 pieces of real property in the Cayman Islands, have always been titled jointly with right of survivorship. Mr. Ebanks, Arthur Ebanks, that is, filed for the dissolution of marriage on July 31st, 2006, and at the same day, he also filed his will. And in that will was a provision that said, I intend that on my death that any property in my name and that of another, as joint tenants with right of survivorship, will pass to the survivor, and I instruct my personal representative to make no claim thereto. The parties entered into a mediation agreement in July of 2007 regarding these properties, and they agreed to try to sell it, to sell them, I should say, all 3, at a minimum price, listing price of no less than $1.5 million. There were several specifics in it as to what they would do if they couldn't sell it in time. Well, the upshot of it was they weren't able to sell. They got, I think, 1 offer. It wasn't sufficient. The mediation agreement was, of course, approved by the court. The parties in the agreement had agreed to have the Florida court reserve jurisdiction, which, of course, is questionable because the properties were in the Caymans. They listed the properties, as I said. They were unable to sell them. Now, the final judgment did not order the property sold. It simply tracked the language of the mediation agreement and said the properties shall be listed. It reserved jurisdiction to enforce the terms of the agreement and the judgment, but beyond that, nothing else.
But is it significant at all that the agreement seemed to have a lot riding on the proceeds from the sale of this property? You know, the mortgage on the marital home was going to be paid off. This was going to be paid off. You know, there seemed to be a lot of things in the agreement that were contingent on the sale of those properties.
Well, that's true. There were. And
and of course, it's unclear. I don't know if it's clear in our record what has happened, with regard to those things in the years since, but the sale of that property seemed to be fairly central to the parties' agreement, did it not?
I don't know whether I would call it central. They certainly, title ownership in the Tampa house, for instance, was contingent upon that. Title ownership to the wife of the Mountaintop Cayman Islands property was central to them selling the 2 I'll call them beachfront, waterfront properties. In any event, Mr. Ebanks, died rather suddenly on December 10th, 2012. The parties had not sold the property. In fact, at that point, I don't think it was even listed.
Can I just ask a point of clarification? In your brief and your opponent's brief, there's a lot of conversation about whether the tenancy held in the Caymans had rights of survivorship to it. Both of you have argued back and forth about that. And it appears to me that it was held to absolute joint proprietors, that inherently has survivorship benefits. Do we really even care about this issue? Because it seems like that really it seems like to me, and maybe I'm being overly simplistic, and this is where I need your help. It seems like that Ms. Ebanks obviously succeeded to the ownership of the Cayman Island property by operation of law, by virtue of the co-tenancy, which seems to me clearly has survivor benefits to it. But it seems like that really doesn't matter. What really seems to matter here is the marital settlement agreement and the divorce itself that provided for the division of the proceeds and a mechanism to sell these properties. And isn't it really, and help me with this again, isn't it your client's position that that I succeeded to this interest in the property and I no longer am bound by that agreement because I'm now the sole owner. That agreement contemplated, joint ownership or co-ownership. Isn't that pretty much, and your opponent's position really is, it's the contract that controls, it's not who owns the property. Isn't that really what the issue here is?
That's what the estate's position is. It's our position that because it passed outside the will, and it was Cayman Islands property, it was not subject to administration by a Florida probate court. And it no longer belonged to Mr. Ebanks at the time he died. So therefore, the estate has no interest in this property, and it has no interest in trying to enforce a marital settlement agreement in a family law court in Florida that relates to property that's outside the country. As I've argued in my brief, the parties were free to comply fully with the agreement as written.
So the estate, I guess to follow your reasoning then, the state is not bound to honor the commitments made by Mr. Ebanks in the agreement?
The estate is not bound?
Well,
I'm sorry.
Does the estate not have the rights of Mr. Ebanks in the agreement?
No, the estate does not have the rights because he didn't, at the time he died, he no longer owned the property. The estate had no interest in that property at the time he died. The parties were free to totally disregard that agreement if they wanted to. They certainly modified it, and the estate agrees that they modified it. They modified it by delaying the sale of it. They modified it by having the dissolution of marriage before the properties were sold. I mean, it is black letter law that anybody can waive whatever rights they have, whether it's by contract or statute or order or anything else. And it appears this is what they did.
But it appears that they also, the death of either party was not contemplated in the agreement at all. Is that what it appears? That's what it looks like.
Certainly, it was not indicated that it was intended, but by the same token, they both were presumed to know the law. They both knew, presumably, that the rights of survivorship existed. So they both knew that if something should happen before those properties were sold, that it was going to go to the other party. And that has to be legally presumed to have known. They had to have presumed to have known that. So our position would be they in effect modified the agreement, that for whatever reason, whether it was economic, the market, they chose not to sell the property as of the time of his death. And it is our position that Florida has no jurisdiction over the Cayman Island properties to convey title.
The property was listed for a period of time shortly after the agreement, correct? For like a year?
Yes, that's correct.
And
I think
so
2009.
So through 2009 or up, and that listing agreement, I think, ended in 2009.
Correct.
And it had not been listed between then and the time Mr. Ebanks died?
Correct. I believe that is true. I think there had been some discussion with Mr. Bloomrose and whoever the realtor was, but there wasn't any. One thing, by the way, I need to advise the court. The circuit court has stayed the order under appeal until this appeal is resolved, and I think the court needs to be aware of that. The fact is, the estate is trying to enforce a provision, a right that no longer existed with Mr. Ebanks at the time of his death. And realistically, what was there to enforce? This was property that is subject to in rem jurisdiction, and Florida does not have in rem jurisdiction over Cayman Islands property. The judgment did not require the property to be sold. It simply required it to be listed. It was listed. If Mr. Ebanks had been alive and had come into court and said, look, we can't resolve this with Diana, we can't sell it, court, what can we do? The court couldn't order partition. That requires in rem jurisdiction. The Florida court could not do that. And in fact, the Florida court did not reserve jurisdiction partition. So how could Mr. Ebanks himself have enforced that judgment? I'm not sure the answer to that, truthfully. But I do know the court couldn't have ordered the property sold. So where is the estate's interest in this property at all?
Well, wait a minute.
Mr. Ebanks?
You know, the agreement, I mean, when you said it just ordered it, the property to be listed, I mean, I think clearly the intent of the agreement and or the judgment was that it be so. I mean, all sorts of things were contingent on the proceeds of a sale. There were directions to offer it first to one adjacent property owner, offer it second to another property, adjacent property owner. I mean, these are all
True.
So I don't think it's fair to say the only thing she was ordered to do was to, or the parties were directed to do or agreed to do was to list the property.
I say that because in the terms of post-judgment enforcement, which the estate is now doing, they have called upon the court to execute its in personam jurisdiction to enforce something that we're saying is unenforceable, and besides that, how would it be enforced? There's no question that the parties intended to sell it, and absolutely no question, but that intent didn't take place. For whatever reason, they may have changed their minds, who knows? But they didn't do it. So they have to take the property as it was titled, as the estate was. After all, the estate's only interest ripens when the person dies. And when the person dies and doesn't have the asset anymore, there is no right to anything, at least in terms of the title. Certainly the parties were able to modify, they were able to delay it, and that's exactly what they did. It's also important because it relates to the issue of, in the in personam jurisdiction, to coerce or force the sale, which the court has mentioned that it has the jurisdiction to do. In personam jurisdiction has been described as a means of specific performance of a prior obligation of an individual obligation. In other words, it's the jurisdiction against the person, not against the property, the rem. And it's an obligation that has been set by a former court obligating one individual for the benefit of the other. For instance, conveying. If in fact this judgment had said, Mrs. Ebanks, you are to convey title to Mr. Ebanks in this property within X amount of days, questionably that would be not within the jurisdiction of the court anyway, but even if it had done that, then for this court to come in, it would be exercising personal jurisdiction over Diana Ebanks because she had not done it. That's in personam jurisdiction because it's requiring specific performance of an obligation the court had already ordered. That's not the case here, though. That's why I'm saying the only obligation of these parties, which they complied with, was to list the property and try to sell it. The court did not order that it had to be sold by a certain time. It did not order that it had to be sold at a specific price. It simply said, try to sell it, list it. So again...
Well, there were maybe not specific price and specific times, but there were price parameters and there were price parameter changes tied to specific times. And that contract was fully enforceable while Mr. Ebanks was alive, and I have a hard time understanding why all of a sudden it's not enforceable because he died. The contract was still in place. The court had jurisdiction over that contract, and that's what drove the divorce. And the fact that he is no longer alive, I don't know how that changes the court's jurisdiction over the contract. The court doesn't have jurisdiction over the property per se, but it does over the contract, and the contract had sale procedures in place, and I would presume they're still operational. I can't imagine why they wouldn't be.
Because the parties have modified them. They have not complied with them. They had not complied with them as of 2012. And also because the property no longer existed, was no longer an asset of Mr. Ebanks.
Well, the asset to Mr. Ebanks is his right to the proceeds upon the sale by virtue of the contract, which was made in Florida, and as you know, the court has jurisdiction on it.
But arguably, he waived that right when he and Diana did not change the title to tenants in common, which they could have done. It would have taken both to do it, but they could have done it. By not,
That's a pretty big leap.
well, Your Honor, actually it isn't, because in the Crawford v. Barker case, that's basically one of the issues too. If the owner of a property, or whether it's an account, whether it's real property, if they want to assure that that property is going to go into the estate, then they had better make sure that it's capable of going in the estate. And leaving it in joint proprietorship with right of survivorship doesn't do that. That was never done. So it has to be presumed, in addition, as evidenced by the provision in his will, that he was aware that the property was with right of survivorship. And he specifically instructed the personal representative to take no action. And again, the enforcement procedures in this case, because the property is in the Caymans, is very, very limited. But because the Florida court does not have jurisdiction over it, the estate, there's nothing in that mediation agreement that gives any consideration to the heirs of either party. Nothing. There was no expectation on the part of the personal representative of the estate that the proceeds were going to go into the estate. If it had sold, it might have gone into the estate, it might not. He might have bought some other property, he might have spent it all.
Ms. Vedder, you're down to your 5 minutes.
Okay. I will reserve then for rebuttal. Thank you.
Excuse me, may it please the court, Martin Newmeyer for the appellee estate.
Can I ask you a question right off the bat?
Yes.
As you can tell, I'm kind of trying to sort something out here, and so I'm going to try to get you to help me sort it out. It's like I tried to get opposing counsel to help me sort it out.
Yes, sir.
Does your case rise and fall on whether or not there was rights of survivorship in the co-tenancy that this property was held in the Cayman Islands?
Absolutely not. Our position is that legal title is irrelevant.
Well, you've argued a lot. You both have spent a lot of time in your briefs arguing that point. So, and both of you seem to think it's, well, actually opposing counsel thought it was relevant because it passed outside the estate, which means it's not an estate asset. So why don't you respond to that position?
Right. Well, primarily our position is that you have to look at the final judgment, the contract that was enforced by the final judgment, not outside issues such as what was the state of title. Consider this scenario, exactly the same situation, but we started out with the Cayman Island properties both in the wife's name. We start with legal title to her, and the contract says it's to be sold. There's a step-down sale. The court orders that they comply with it. The court finds that it's marital property, or for whatever reason, it finds that it's able to enforce this particular agreement. And then when the husband dies, she says, well, I don't have to pay it anymore because it's in my name. That is the crux of their position, is if it's the legal title governs over the contract. Our position and the case law is, no, that's not true. You have to look at, according to the Supreme Court, Davis versus DeGiuste, it's the final judgment that adjudicates all the parties' rights. If it's in there, it governs. If it's not in there, it doesn't exist.
Mr. Newmeyer, how is that affected by the provision in the will? Which, I personally, I didn't do a lot of estate probate work when I was practicing, but it was an odd provision, it seems to me, to say if I have any property held in that's titled with rights of survivorship, that property goes to the survivor, and I direct my personal representative to make no claim thereto.
Right. Perhaps that would be relevant if the will had come after the mediated agreement. He executed the will first, then he executed
but the
mediation
an outside agreement can't change the terms of the will, and my concern is whether your client had any authority at all to bring this action.
Right. There is some argument about that. The statute allows the estate to step into the shoes of the husband.
It does, but you have a provision in the will that appoints the personal representative.
Right.
That specifically directs the personal representative not to take this sort of action.
The court, the will has specific language about what specific terms or types of title. It doesn't say, you know, we have to split hairs, obviously. It doesn't say any property that's held as absolute joint proprietors shall not inure to the benefit of the
It says,
former
and,
spouse.
and the copy of it here is kind of bad, but it says, any property in my name and that of another as joint tenants with right of survivorship. And you're suggesting that since this title is held under a different kind of verbiage.
If I were to split hairs, that's a minor argument I would make. The primary argument is that that provision was replaced by the terms of the mediation agreement. The mediation agreement said, in effect, this property is to be dealt with in this particular way. He could have said,
So if he had made any other, and if he had entered into any other contracts with any other person that he held joint property, that he could affect this provision of the will by subsequent contract outside of the will.
absolutely, if it was executed with the appropriate formalities, which this one was, if it was ratified by court order, which this one was, then yes, absolutely. If I have a will that says I disinherit my wife, and then you come into the final judgment and you say, well, the wife will be assigned as beneficiary of my retirement, my Social Security, she will continue to be the beneficiary of my insurance. Yeah, you created an old will, and I'll call it an old will.
Those sorts of things pass outside of the estate. And the point is that number one, and if I understand this correctly, from reading the briefs, he executed this will on the same day that he filed the divorce. That's what was stated in the briefs.
It's stated in the briefs. It's not totally clear from the record.
Okay. Executed this will roughly the same time as he filed the divorce. So certainly he was aware of that provision when he filed the divorce.
Yes.
Aware that this property is titled jointly, right? He inherited it correctly, so he
Yes,
put it in joint names.
Possibly, yes.
And never did not take any action in the divorce proceeding to say, hey, we need to get the title back in my name, we need anything like that. Never did anything like that.
Yeah,
before or after the divorce.
Evidently, it was acknowledged to be marital property, despite the fact that it was inherited.
Well,
that was a matter of negotiation.
The agreement doesn't say it's marital property, but it does give her the benefit of her interest based on the title.
It gives her a defined interest.
Right.
Again,
to
whether
split the proceeds equally. And he never changed the will.
We have no indication he changed the will. That's correct.
Well, and you're writing on a particular will, so.
The only reason the will comes up is the former wife's defense to it, the appellant's
Well, you have
defense
to, I mean, and you have letters of administration, obviously, that from the personal representative to take actions, but his authority, I think, is defined in the will, is it not? Isn't that the source?
It would be that and the probate estate as well. The court, Your Honor, you have an interesting point, but it really wasn't raised within the context of this temporary order as being an issue. When the trial court made a finding that the estate would stand into the shoes of the former husband, enter that initial final judgment or initial temporary order that said, you know, she's prohibited from conveying the property or alienating the property.
What's troublesome, though, is the point you just made, is that the estate would stand in the shoes of the former husband.
Yes.
But by operation of law, upon his death, the former husband was divested of any interest in this property. That appears very clear to me. And I know you've argued to the contrary, but I have to tell you, I'm not.
And his will has directed the personal representative to take no contrary action.
Yeah.
Our position, Your Honor, is that, again, what was in the will was replaced by the final judgment, the agreement that was directed at specifically this property. We have a general provision in the will, a general overall provision. Then, subsequently, we have a new contract which specifically and directly addresses this particular asset. And as I noted in my brief, other assets were dealt with in terms of what happens if I die. So you have some of them, this is what particularly is going to happen in the event of my death. For this particular asset, there is no such provision. The court can't presume one, the court can't impose one. And there's a final judgment of dissolution of marriage, a court order that ratifies this particular agreement. The probate, maybe the will is going to get overthrown. We don't know. We don't know if there's a court order that says this particular will is going to be probated. And that issue is still open, I would submit. If, in fact, the final judgment comes in our favor, and the former wife is ordered to sign certain documents, and a buyer appears, and the property is sold, and that money is sitting there, as the former wife agreed it would be in the mediated agreement, and as she was ordered to do, I don't see why, we're not at the point of having a final order yet. We're still at an interlocutory stage. That's why my position is that particular issue is really not ripe here today. It wasn't particularly briefed. It wasn't particularly included in this order. That is more a matter for another day. Our position is when you have a formally executed document, a will that provides one thing, but then you have a subsequent contract, anybody can change their will at any time. Anybody can enter into an agreement. What if the will left this property to her, and then in the agreement they said, well, we're going to sell it, and they had sold it?
Well,
could she then go and say, wait a minute?
That's a different matter in terms of like the asset is no longer, his or no longer titled that way.
Yes.
And that's sort of my point. Didn't change the title. They agreed that they were going to sell it, but they didn't.
Right.
They rejected an offer.
Right.
Correct.
Yes.
And never took any steps to change the title, and never took any steps to change that provision in the will.
Yes. And this is where we start getting into decisions of fact, not decisions of law. The former wife, is asking the court to infer that because the will was never changed, because title was never changed, that would tend to promote her position that it was agreed that legal title would bind the parties. But inferences are...
and I'm not all that concerned because you guys have spent a lot of time, understandably so, about what his intent was.
Right.
I'm not sure that has any bearing beyond what's on the documents.
The inferences, they're trying to argue, what did this mean, what did that mean? They're on appeal. All those inferences are taken as a matter of law in our favor. If the trial court said, and I spent a section in the answer brief arguing exactly this, if they didn't change the title as they could have, well, yeah, it would have cost $175,000, and the mediation agreement is clear that they're both living on Social Security and have no other liquid assets. There are other inferences that might arise from the same fact pattern. Maybe they couldn't afford to make the change, but they intended to have a complete provision dealing with how this property is distributed. Yes.
It's not generally sufficient to come in and challenge it and say, he intended to change his will, but he didn't have the money to.
Right.
That's not going to fly.
Right, and he didn't need to, Your Honor. That's the former wife's argument. He should have come in and changed it because that would have given some indication that he intended a particular resolution of this asset. But we already have a contract ratified by a court order directing the parties what to do with that particular asset. Once you have a court order, why would you go back and spend more time fine-tuning it? You're already under a court order. And that's the inference that the court should accept in this case. Again, once you've dealt with it, we know exactly what's supposed to happen with this property. We have a starting list. We have a countdown, annual reductions in price. We have automatic sale on one provision. We have optional sale if it's within 10%. All this is completely dealt with. Now she says, oh, wait a minute. Let's look at what the will would have said. Let's look at something outside of the final judgment.
Because the thing is none of those things in the contract, other than that they offered it, they listed it, and it never sold, and the listing agreement expired, and they never listed it again.
Right.
So they didn't really follow through on the contract either.
But that would not stop either party from asking for enforcement subsequently, Your Honor. And there was an explanation?
Unless his will directs his personal representative not to.
That was not given in any of the testimony as the reason why it wasn't.
I'm looking at the language of the will.
Yes, Your Honor. And again, whether it's the will or whether it's the legal title, these are all things outside of the court order, and the court is charged with enforcing the court order. The law from the Supreme Court says you enforce the court order, and all the rights and obligations that could or should have been adjudicated are adjudicated within the terms of the final judgment of dissolution of marriage. That's what we have here, and that's what we're asking the court to enforce. And once the court entered an order, I would submit that any old agreements, any old wills, anything else are now governed by the provisions of the final judgment. I think that's the law. I think it's mandatory, and that's why I think this particular order should be affirmed on appeal. It merely orders the former wife to do exactly what she was previously ordered to do. It says, okay, get off the stick and do it. You already know what you have to do. What you have to do is what you agreed to do, and you cannot trump that by saying, well, you know, by sending in some documents, I now am in a superior position, and I should now receive the property. In fact, you might even argue that once the wife, the former wife, submitted her delete on death provision and got the title changed into her name alone, the property is no longer joint right of survivorship. It's merely a property in her name that the estate has a claim to. It no longer falls within the will because of her actions.
Well, it never fell within the will to begin with.
That's our argument.
I mean, well, because because of the way it was titled before, it would not have come through the estate.
Possibly, we're presuming, and I would assume that's probably Cayman law, but we don't know for sure. Again, it appears very apparent, but do we really know? There are nuances in Florida law that would not be apparent upon, you know, right of tenancy by the entireties. Would a person from Alaska figure if you get divorced, you no longer have a unified ownership in the property? That's a nuance of Florida law that may not exist elsewhere. We don't know what the nuances of Cayman law are. I referred to a specific provision that...
Well, it's a nuance of long-standing common law.
But Cayman law is not common law, it's statutory. And I cited a provision in Cayman law that appears to say the courts there can determine title based on equities.
Well, but the Cayman government has, upon request, examined the matter and taken the position that Ms. Ebanks is the sole owner of this property by operation of law under their own laws. I mean, you've told us that in the briefs.
They processed a claim that she put in, and they issued a new title based on her request.
And I'm sure they wouldn't have done that without some sort of legal position being taken on that.
If that were true, Your Honor, we wouldn't need courts because the clerks would handle everything properly. Whether the clerk was aware, whether there was a provision in the delete on death clause that said, are there any other claims to the property? And she checked, no, we don't know. That is not in the record before us. We know that she submitted something. Whether or not they would have recognized that, whether or not it was disclosed to them, we don't know. We don't know what a foreign country's laws are. And that's why our position is, it doesn't matter. It doesn't matter. The only thing that matters is the status of the title such that the former wife still has the ability to comply with the terms of the final judgment. For instance, if she had deeded it to her daughter, then we might have an issue. She might not be able to do that. Fortunately for the estate, she's under a court order not to do that. But unilateral actions after you're under a final judgment, which are inconsistent with that, cannot be and should not be approved by the court. I mean, the case law and all of our jurisprudence is, once you get a final judgment, you got to follow through with it.
But this is all triggered by a unilateral action, which really is the death of one of the parties. So, you know, it's not as though Ms. Ebanks took this upon herself. I mean, she basically did what you typically do in these situations. You tender a certificate of death to the jurisdiction where property is owned, and things happened, you know, in the normal course after that.
It did, however, it wasn't self-effectuating. You did have to send in forms. You did have to do a certain request. It was not automatic. Now, the argument is the vesting was automatic and the actual issuance of a new title wasn't. It not infrequently happens. You know, grandma dies, and lo and behold, the property is still in the name of great-grandpa that left it to her. Nobody ever bothered to get the title changed. Happens all the time. And in this case,
Well, but it happens all the
Yeah,
time.
but ownership has already passed. The
Right.
question is, we need to clear up the record for,
You record the
Title
certificate of death, and that basically is pretty much all you need to do most of the time. In most jurisdictions, I have no idea if it's true in the Caymans or not, but it appears from the briefs I've read, that's kind of how it happened there.
that's absolutely true, Your Honor. She submitted it. Evidently, they changed the title. Our point is it doesn't matter. Could have been in her name to start with. It wouldn't matter. Could have been in his name to start with. Wouldn't matter. Title doesn't matter. What matters is it was specifically addressed by the final judgment. We know what's supposed to happen to it. You can't unilaterally do things contrary to the final judgment. And that's what the court has ordered. Not that she sell it, not that she do anything unusual, simply that, literally, that she comply with the final judgment. That's the order that's under appeal. What she's saying is, don't require her to comply with the final judgment. There's no legal justification for that. That's our position.
time is wound down, Mr. Newberg.
Thank you, Your Honor. I apologize for going over.
Oh, good.
So the fact that this property is in the Cayman Islands makes this case a little more interesting, but it's really irrelevant, right? I mean,
No,
it would
it's
be no difference if this property were in Collier County, titled in the same way with the same set of facts.
Oh, I think it makes a great deal of difference, because I think it goes back to one of the basic problems with this case is that the Florida court doesn't have the jurisdiction to try to do what it's doing right now. It found, which is why we're appealing, that the estate was equally entitled to that property. And we are saying, no, it isn't, because the Cayman Islands, and by the way, I submitted a notice of a supplemental authority yesterday, simply attaching the laws, the Cayman Island laws that we all were referring to. So it really wasn't something new. I'm not sure if the court got it.
We haven't seen it, but I'm sure
Okay,
it's
but it
in the
is
process.
there. It sets out land law revised 100 subsection 1 and subsection 2, and it says that the interest shall in any dispositions made only by all the joint proprietors, and on the death of a joint proprietor, the interest shall vest in the surviving proprietor or surviving proprietors jointly. And then the next provision allows for that to be severed, but both parties have to agree. The whole issue, one of the whole issues in this case, though, is the estate's lack of interest in that mediation agreement and in that final judgment. They had no expectation in that. So what are they doing in this case to begin with when there is no asset that belongs in the estate? And that's the
Well, you know, but Mr. Neumeier poses the hypothetical that what if this property had been titled in your client all along, and as part of the agreement had been that, you know, that it would be sold and the proceeds applied the way the agreement said. His death would have had no bearing on that, correct?
I'm not sure that that's, I'm not sure I'm following that hypothetical.
The hypothetical is that assume this property was titled in your client from the start, but she agreed as part of the mediation agreement in the divorce to sell it and give him half the proceeds, and the proceeds be applied the way the agreement was. His death would have no impact on that obligation, would it?
No, I agree. I agree. If she had the obligation, and that's where the in personam jurisdiction to coerce a conveyance comes in, if she were under an individual obligation to sell it and give the proceeds to him, then perhaps it would be enforceable. But again, where is the estate's interest in that? It would seem to me that here, the estate, first of all, had to prove they had a legitimate interest in that property, and this is where I think they fall down.
Or, you know, I think what the state is saying is it has an interest in the proceeds of the sale of that property.
Well, first of all, they have to have an interest in the property before they can get an interest in the proceeds, would they not?
No, their interest in the proceeds is pursuant to the contract, the mediation agreement.
But they're not a beneficiary in any way, shape, or form under that contract, and that contract has long since been modified, changed, waived, whatever. And I'm going to go back to the Crawford case, because I think that's very important.
Well, the Crawford, though, involved the competing contractual obligations, right? Crawford involved the contract in the divorce and the contract in the deposit agreement.
Correct.
We don't have the contract. We have the contract in the divorce. We don't have a contract on the other side here, do we?
Actually,
We have title.
Right, and I want to get to that in a minute, but what Crawford does say is that it is up to the person, the owner of it, if there is a question as to where the death benefits are going to go, then you have to look at the designation. And these aren't fiduciary accounts, they're not bank accounts, but they're titled to real estate. All right, there's a question, I suppose. Did he want the property to go to her, or did he just let it go to her? So you have to go by what the title says, and the title says survivor. And legitimately, that was with Diana Ebanks, and she did nothing wrong. The intent is not an issue in this case. It definitely is not. And certainly we're not arguing the will should have been changed. I'm not sure where that came from. Our position is that the estate doesn't have any position being in this case. The estate's, the asset was never part of the estate, and Florida does not now have the authority to require or force a sale of the Cayman Islands property.
Time's up, Ms. Vedder.
Thank you.
Thank you both very much.
Very interesting case.
Yes. Finally, didn't have any other cases.